evening, ladies and gentlemen. This is Sima from Spring Spirit Nation on the Indian Day School Facebook page. The show is not about me. I'm just mediating and moderating questions. The stars of the show will be on shortly. There we go. There we go. Welcome, Pam, and from PLM Law, and welcome, Michael. Tell us a little bit about yourselves.
Okay, can you hear us? Okay, thanks very much. Michael, I just wanted to test that we can hear you.
Can you hear me?
Yes, okay.
Oh, good.
Thank you, Sequin. It's very nice to be here to be live on this Indigenous Day School Survivors Information Group podcast. Thank you very much for inviting us. And Michael and I are pleased to be here to, I think, answer questions, give some information, and to give any assistance and any help that may be required. This is just a presentation for informational purposes, and we'll answer questions for general information. And if anyone has any specific questions, I think there's a private chat on the side, but also we'll be providing our toll-free number and our email and our website if anyone has any questions they want to ask us afterwards. So again, we're really pleased to be here. And I just want to be clear from the outset that we are not Gowlings. We're not class counsel. We are not the administrator. We're an independent law firm that is assisting day school survivors in putting forth their day school claim. So just to tell you briefly about ourselves, and we'll move on from that very quickly. I've been a lawyer for over 30 years. I have a focus on restorative justice and human rights. I also practice as a mediator, and with a restorative justice focus. I work a lot in Indigenous communities and First Nations across the country. I worked for 7 years with residential school survivors in that settlement process. Other work that I do with First Nations and Indigenous communities include being the chair of the PEI Law Society, Canadian Bar Association, Aboriginal Law Section, member of the National Executive on our Call to Action Committee, and also we're involved in implementing TRC calls to action and a reconciliation plan for the lawyers here in my region. And so that's sort of some of my background. I really enjoy working in the community. I enjoy working with residential and day school survivors. And so I'm really honored and pleased to be able to do this work and to assist where I can. Michael, you want to say something about yourself and give a little bit of background too?
Sure. Thanks, Pam. My name is Michael. I'm originally from Mi'kma'ki here in Atlantic Canada. I grew up in Toronto, and my law journey took me back out west to the University of Saskatchewan, and I went to the Native Law summer program there. During my time in Saskatchewan, I learned about the teaching of Education of Buffalo, and I created a Facebook group with over 15,000 members. I'm also the moderator of Indigenous Day School Survivor Group. And I also wanted to take a pause right here that understanding that there's going to be some emotions that will come out when you're thinking about the day school. It's okay to take a break. It's okay to take a pause. I also wanted to share that there is the Hope for Wellness hotline, and that's 1-855-242-3310. And also there's the Hope for Wellness online too. That's hopeforwellness.ca, and it's an online chat. It's something I've used as well. So I'd just like to share that with you before we start. So I'd just like to take it over back to Pam now.
Okay, thank you, Michael. So we just, I think people can pose questions. We can watch the chat. Sequin, I'm not sure if you're going to interact in that or with any of these questions, or else I can just sort of go into, discussing some of the key issues and maybe some of the key questions that we have seen coming up and that we have certainly heard from survivors when they call us or, reach out to us on our Facebook page or on our website. So I guess going into, one of the key questions we often hear is, how does the day school claim settlement process work overall? And maybe I'll just give you sort of an overview. And I know that many of you who are joining us, have been working in this and helping each other on this group, Facebook group, and working in your communities and that. So, for those of you, I may be, some of this may be repetitive, some of it may not. And I hope that, some or all of what we share with you this evening is helpful. But I'll just kind of talk to you overall about the key issues and some of the overall structure of this settlement process. So it was a large settlement arising out of the class action, the McLean settlement, the McLean class action for day school survivors. The class member size was estimated to be in the range of 140,000 survivors. The class action and this settlement process covers fairly similar, but can be different in some ways, but similar harms and physical and sexual abuse, similar to the residential school settlement agreement. But again, as I said, it's different in a number of respects. So it does provide for compensation under what's described sort of as 5 levels of abuse, and the compensation range for that for level 1 is $10,000 up to the highest level of harm and abuse up to $200,000 at level 5. And so there is a harms grid or an abuse grid, which I will go into in some detail as we go forward. The claims process started on January 13th, 2020, and that's an important date. And I'll tell you why. Because we're hearing from many survivors that they say, oh, we put our claim in last year, or we put it in the fall. And, it's important to know that this claim process did not start until January 13th, 2020. So any survivor out there that thinks that, their claim is in and they put it in last summer or before January 13th, 2020, it's not in, because the claims process didn't open prior to January 2020. What was happening, though, was that Gowling's class counsel was taking registrations and getting names. And I think, there was a bit of a registration process. And so some people may be under the misunderstanding that that was actually their claim or their application going in, and that's not the case. So it's really important to recognize that. And that can also be confirmed as well. Whether your claim went in or not can be confirmed by making a call to the administrator, giving them your name, your information, and they will confirm whether they've received your claim. And just going back in terms of important dates, I told you the date that the claims process started. When the claims process ends, the deadline is the deadline to submit a claim is July 13th, 2022. So it's very important to know that the claims process started in January 20 and ends in July of 2022. There is a possible 6-month extension that's not confirmed yet. So, it's very important to recognize the deadline, at least presently, as that July 2022 date, and make sure that your claim is in before that. The claims process, as many of you know, is strictly a paper filing process. And it is really important in that putting forth that paper, that application, is to put forth your full story and to make sure that you receive the highest compensation that you deserve, and also that your full story gets out there, because there's a historical aspect to this. And just like residential school survivors' stories were told through the Truth and Reconciliation Commission and through the stories that were provided in that independent assessment process, there's a historical record of that. And Canadians are learning about that. Non-Indigenous Canadians are learning about what happened to residential school survivors in these schools. And I think it's equally important that the story of day school survivors is understood and heard, and all of that. I will get into this a little bit further on, but it's really important as well at the claims at the higher levels 2 to 5 that there may be some requirement for supporting documentation, and that's really to best prove your claim. If supporting documentation can't be obtained, or if the record's missing, there is this process of a sworn declaration, and it's under Part 6 of the application materials, the claims form, and I'll talk to you about that a little bit further on. So in that first question, I'm just talking to you about how the day school claim settlement process works overall. So just talking about some of the key issues that I've just gone through with you. I'll just, again, touching on that as well, just to know, there are two key entities, I guess, or, people or groups involved in this. And this is Gowlings, the law firm out of Ottawa that was class counsel, and they provide free legal assistance to survivors. And there's also the administrator, and the administrator is tasked with determining eligibility. So these applications go to the administrator, who is Deloitte's, and they make the decision about eligibility of your claim and the amount of compensation. So that's sort of just a good overview of how the claims process works overall. I've already touched on sort of a second question that we had sort of thought that would be an important question for people would be, when does the process start and when is the deadline to submit a claim? So I've touched on that. I also want to talk about, we're hearing a lot of questions about the schools. And, I attended this school in my community or on my reserve. I don't see it on the Schedule K list. Can I claim? Is my school eligible for compensation? And this is really, really an important issue, because let me tell you about Schedule K. And Schedule K is the list that was agreed to in the settlement between Canada, the government of Canada, and Gowlings, the law firm. These were the schools that were determined to be schools that, according to their records, were schools that were run by the federal government at that time as federal Indian Day schools. And so this Schedule K is a exhaustive or definitive list of the schools that compensation can be claimed for. And so it goes by province, it goes by school name, it gives some other names that schools went by. It talks about opening dates, and it talks about location and maybe the religious affiliation of the schools. And so this piece is really, really important, because you can claim if your school is eligible. If your school is on the list, you can make a claim if it's between the years that also are referenced as the opening date and the closing date, during which Canada had responsibility as the federal to run these schools. So, what you want to do firstly, because we know that many of these schools went by different names, variant names. Sometimes they just went by, Six Nations number so-and-so school, or they went by the name of the community, when in fact in Canada's records, they had an official name that maybe, many day school survivors didn't actually even know the official name. So it really is important to get that assistance on whether your school is eligible, because you might look at Schedule K and you might say Alberta, school name, in High River, they have a name of the school here on this list, but it by a different name. And so it really is important to drill down and get assistance to make sure that you don't say, oh, well, I don't see the name of my school on the list, I guess I can't apply, because that's really not the case quite often. And we find what we're doing, and survivors come to us or reach out to us, they ask us, about their school name. They maybe give us a different name, and we're able to ask questions. We're able to maybe do some more research and get some better understanding as to whether it's an eligible school. You can also call Gowlings, and they should be able to assist you with that, or even try the administrator as well. Or if you're even not sure, and if you're putting your claim forth, on your own, at least put your community and the school that you knew the name of it by. But what we're doing is, and I think this is really, an important piece, and where we can really be of assistance, is really trying to understand and maybe even doing some research within your community or other day school survivors who have claimed and maybe have had their claims be successful. Really understanding what the administrator understands to be the name of the school. Because if you put a name that the administrator doesn't understand or see clearly as the school name, and you don't put the community, or they may not necessarily do the research, or they may see it as not an eligible claim. So this piece about really putting the name of the school and end with the name of your community is really important. So again, as I say, many survivors are reaching out to us and we're able to provide some assistance on that, and Gowlings can, assist you with that as well. But if in doubt, put the claim in, put your community, have a look at this Schedule K list, and really do some research about the different names of the school. So that's the Schedule K issue. In terms of a fourth question, we had kind of set out that we've been hearing questions about what assistance and what resources are available to assist former day school students or day school survivors, in submitting their claim. So I've talked about Gowlings being class counsel, and how that worked is that settlement agreement provided for just that one law firm to provide legal advice and services. And so they've set up a toll-free number as well. They have a website, and they're doing some sessions as far as I'm aware. And you can talk to them and they can assist you in your claim. They don't do the gathering of any supporting documentation though, and they don't put your claim forth directly to the administrator. So they can assist and give some advice, but they don't sort of work on one-on-one with you in gathering the documentation for you, if there is documentation to be gathered, or in submitting the application directly yourself. So in terms of what assistance and advice is available, I've mentioned about Gowlings, their free advice. There's now, since July of 2020, there was a court order obtained to allow day school survivors to obtain their own lawyer if they so choose. And so some lawyers like myself, many whom have worked with residential school survivors, many who have worked in this process and understand it, are offering our services. And that service is one-on-one. We are assisting with the application. We're assisting obviously with the Schedule K issue. We're assisting in gathering what supporting documentation may be helpful and to help to make your case strong and to put your best case forward, your best claim forward. And we are submitting all of that material directly to the administrator. So we say to the administrator, we are legal counsel for Michael Sima, who's, say use him as an example, is a day school survivor. Here's his application. We have verified that all of the necessary material and supporting documentation and all of the, identifications and information that's required in this application, we ensure that that is put forth fully. Because another thing that we're hearing, and I will talk to you some about, the complaints of delays by the administrator in getting these claims through and assessed and hearing back from them. We're hearing from the administrator that, there are many claims coming through where there are pieces of information missing. And so that causes significant delay. So, when we are acting for our clients, we're making sure that that claim goes through directly to the administrator. We get confirmation that it's received, and that we make sure that with our checklist, everything that had to be put forth is put forth at that time, so there are no delays. And so I guess in terms of resources and assistance, we've been watching, and we're very, pleased and impressed to see survivors helping each other and sharing information and all of that. So, these are some of the resources that we are aware of in terms of assistance that you, can get in putting your claim forth to the administrator. I'm just looking for any question by anyone in the chat, or any questions that are coming forward. So we're happy to answer with this live. So I'm now going to talk some about a question that I have set here in my questions as question 5. And this is where I'm going to really get into some detail about explaining the abuse and the harms grid and the levels and how that all works, and how the administrator, may be assessing and analyzing, these claims for compensation. So before, I think maybe if we can put the abuse and the harms grid up, I want to talk a little bit about, just to give a trigger warning on this. And Michael, maybe you want to speak to this a little bit.
Yes, it's a sensitive area for sure, and just like how I'd mentioned before, if you're near someone close to you, please, take a break. It's okay to take a break from this. You can always, again, call the Hope for Wellness hotline, 1-855-242-3310. Also, you can also type online, hopeforwellness.ca. You can just do online chat, and that would help you if you need that help.
Thank you, Michael. And again, we realize, the trauma and the sensitivity and the sensitive nature of people's experiences at the day school, and this abuse harm grid that we're now going to talk about, and we may be able to put it up. I'm not sure, Sequin, if that's possible, or whether whether it's advisable. So, but I do want to get into I want to get into kind of talking about the levels a little bit more and how the administrator may assess it, and why it is so important that satisfactory detail be put forth in the application and in the claims form, and also, again, if there is any supporting documentation, to put it forth. Again, I just want to reiterate that documentation isn't necessarily required. So proof, so if you think about, well, the priest sexually abused me, nobody saw it, there's no proof, so I can't claim. I just want to be very clear that that's not the case. Proof of that nature is not required. It's telling your story in the narrative, in the application, and giving sufficient detail so that the administrator can really assess it and do an analysis as to which level it may fall under. Seguin, that's more the documentary supports. I think the abuse harms grid, I'm pretty sure you have it, although I was looking at some slides that we had sent. But if you do have the abuse harms grid, that's what I'm referring to now. So just talking about these different levels, the detail that you provide or don't provide can really make a difference between each level. And so, level 3 and level 4, there's quite a significant difference in the compensation between each of these levels, $50,000. And so, that narrative and really having it describing, having it fit, some of the requirements or some of the descriptions under the levels on this harms grid or under this model, is very important. So what we do, for example, in assisting clients, in hearing their story and maybe asking some questions and, in a compassionate, gentle way. As I say, I've worked with residential school survivors for a number of years, and I understand how difficult this is and the sensitive nature of it. So, and we also understand, progressive disclosure, that stories can sometimes come out at different times and maybe not all at once. And so just having that patience, and setting that up for whatever's best for, our client that we're working with. But sometimes, we can ask questions in such a way or get the story out, in such a way, because we're so familiar with these levels and what might fit under a 3 or a 4 and how we, really want to present it and how you want, your story to go in there. And again, so to make sure that you receive the compensation you deserve and that the full story is there. So, for example, under this harms grid, there's, sexual abuse harm, and there's different levels depending on the nature and what exactly happened. But there are things that happen to people of a sexual abuse nature that you don't see stated clearly in these levels, but they do fall under it. And so it's just really wording it properly and understanding which level they could fall under, because these levels aren't exhaustive. And so and the physical abuse is a little bit more, there is a little bit more required in that, because that does require some harm. So not only that the physical abuse happened, an incident or more, but that there was some harm caused. And so we see at level 2, the harm to have been caused by some kind of a physical abuse or an assault would be considered and assessed as, was it serious and but temporary? So maybe requiring some bed rest or being knocked unconscious and maybe having concussion after that, or even a broken bone. And then, as you go further in this harms grid into level 3, the test is more that there was some permanent or long-term injury or impairment, which can be either physical or mental or psychological or PTSD, something of that nature, or disfigurement. So, it is really being mindful of where things fit in this abuse and harms grid, and the important details to provide. And so, we are able to, as I say, when we work with our clients, to really be able to provide some assistance in that, and it can make, quite a big difference. Quite often we find, in doing this in a careful and well-considered manner. And again, I did mention earlier about any supporting documentation. So, for example, especially if you get into a physical abuse claim and there is some requirement of some permanent or even just long-term harm, relating to an injury, what we may often do is at least seek some medical records. But again, if those medical records aren't obtainable, if they're missing, or if there's nothing in the records, there's the ability to use that statutory declaration that says it's all true and there was no records or whatever. So that is a sworn declaration saying that you're swearing that it's true, that you did have that physical injury and that this did happen to you and all of that. So as I say, it is helpful where there is information to be obtained because it makes your case stronger, but it's not it's not fatal if that information isn't obtainable, because of that Form 6 is really, able to assist with that, and that's statutory declaration. So let me talk about that supporting documentation. So that's the sort of what's up here on. That's the abuse, sort of the part 5, the abuse harms grid. And now I'll talk about sort of question 6 about what supporting documentation is needed to put forth a claim or application. And so I believe, Saquon, we have a slide on that as well. And it's about documentary supporting documentation. It does have the levels at the top, but the top of it says documentary support for levels 2 to 5. And thank you very much. And so some of these documents that we're showing you, like the harms grid, like this sort of submission, this is right out of the claims application form, which is a 16-page document. So I just want to take a little bit of time to explain it. And again, as you see on this, to the left of this chart, it talks about the support. So for the level that you're claiming. And so, and always in level 2 to 5, there's always the requirement of this written narrative, and that's the detail that I've talked to you about some. As you go down further, even evidence of school attendance, and I know, we've heard from clients and survivors that say, my school is burned down, or they have no records of me there. And again, that's not fatal to your claim, because again, you can provide that statutory declaration, but also other ways that we provide support for attendance could be if you had school pictures, or if you had a classmate that went with you, they could write a statement to say, that so-and-so was my classmate at this day school. She was there during the years, she or he was there during the years that I was there, and all of that. So family, friends, all of that. So you kind of see under this chart, where you can attach documents if they're available, and always if they're not available, we can use that statutory declaration as a fallback. But, we are quite experienced and creative in, determining ways that claims can be supported. And so, let me give you an example that we're coming across quite often with our clients. And that is claims that I think, not everyone would realize would be something that would fall under this, because it's not laid out clearly in that abuse harms grid. And so we're hearing from a lot of survivors, and I know that many of you have talked about this and you're familiar with this, but for those of you that aren't, we do know that in many of these schools, there were dentists that came in, or students were sent out from the school to go to some of these dentists. And we do know that abuse happened in those instances. And that is something that is claimable under this process, depending on the circumstances. And it has potential to be a high level claim. So let me give you, for example, I have some clients that were sent to the school dentist, or the dentist came into the school and they had their teeth pulled out, and often these were permanent teeth, and they were pulled out, for no reasons. And many of them were pulled out quite brutally, without freezing. And the trauma and the physical injury from that, in our view, is a high level claim. And so what we're doing in those cases, for example, is obviously clearly putting it in the narrative and the story and giving the detail that's important to put in, so it makes the administrator and the assessor's job easy to find, in favor of your claim. But also, when our clients have a present dentist, we get a dental, what we call a dental or a medical legal report from that dentist who can confirm, yes, their patient, my client, the x-rays show that they have some missing permanent teeth. They have told me as their dentist that this is a story, what happened to them, and that kind of thing. So, that's where we really strengthen those kind of, as I say, high level, potentially high level 3 or 4 claims to do with, abuse by the dentist. So that's just sort of an example of some of the additional documentation that can be obtained to really strengthen your case. And I think it's also an example of, in you looking at the abuse and the harms grid, it not setting out everything that can be claimed for. And so that's where, we really bring value, we think, in others that are working and giving assistance, to really, really recognize and pull out where a claim can be made that maybe doesn't seem clear or apparent in the abuse harms grid, but we know that it does fall under these abuses. And so here, on this slide, we are talking about the sworn declaration that's in Part 6 of the claims form. And so that's when there is missing documentation, or we're unable to get any additional supporting documentation for the higher levels 2 to 5. And so what that is, that sworn declaration is a statement signed by you, a day school survivor, in putting forth your claim. And it is signed by a guarantor. So that could be a lawyer or notary public or commissioner of oaths, and even an elected official or community leader, chief counselor, or other professionals, even your doctor, a police officer, teacher, someone of that nature. And they're not required, or they don't have to see your claim and all of the detail of that. They simply sign your sworn declaration. So obviously we're assisting our clients with that. That is part of what we also do in making sure all of the right paperwork is signed and put forth, when we are putting forth claims for our clients and for day school survivors. So I don't see any further questions on that. But let me just go back a little bit to talk more about sort of the test and what the administrator might do in assessing the claims. And so, certainly the administrator will first look to see if your school is eligible, and the years that you were there, whether they fall under those eligibility years that are in Schedule K. So the years that the schools were run by the federal government, because the federal government, was the defendant in this class action and in this settlement, and they're paying for abuse that happened, in the day schools during the years that they were responsible and that they were federal day schools run by the government. So again, just reiterate, that's what the whole Schedule K piece is about, and the whole eligibility criteria. So, that's one of the first things that the claims assessor or Deloitte's, the administrator, will do in assessing claims. They will then look at And when I'm talking here, as you may notice, and I will touch on level 1, but what I'm talking about here, today in this information session are the higher level claims of level 2 to 5, that compensation from $50,000, to $200,000, where there is more required in putting forth the application than if you were putting forth a level 1 application. And that level 1 application is to do with, that level 1 application is for $10,000, and there's no requirement for further work to be done. It's a simple process. And for those that didn't suffer these level 2 to 5 abuses and harms, many survivors have represented themselves and put forth those claims. We have, however, and we are very aware, as are many others, that there have been many survivors that misunderstood this process at the beginning. I think initially felt there was some rush, but also felt that didn't understand the levels 2 to 5 and put forth a claim only in level 1, and are now learning more and looking back and saying, I wish I had have known, or I wish I had have had assistance or some advice, because I would have put forth a higher level claim than level 1. And so, there's a lot of discontent about that, and we get that. This is one of the reasons why in July, the court gave the order, and one of the reasons why ourselves and other lawyers are out there trying to get that assistance and that advice out there, so that there aren't misunderstandings, that people aren't, really upset in the end that, they really should have put forth a higher level claim. They really didn't know about it or know how to do it and all that and all of that. So, so going further into talking about claims being assessed and what the claims administrator does, they look at, in this level 2 to 5 claims, they look at the narrative, they look at the detail of the claim and the story that is put forth, and they see where it fits into that level 2 to 5 harms grid. They also look at, any supporting documentation that is put forth as well, and they make a decision. Let's say, for example, and let me use the dentist one, for example, and I'll go back to my my story about, clients that I have that their teeth were pulled out, permanent teeth were pulled out, and that left a permanent impairment, and suffered the trauma and the physical abuse of going through that. And so, arguably that's between a level 3 to 4 claim. It depends on the specifics that are provided and what actually happened. But that's where it is so important, and there's such close similarities between whether it's 3 or 4, and how that's presented and the story that's told can make the difference between, the administrator assessing your claim at either a level 3 or at a level 4. And as I said, that's a $50,000 difference. So some of these details are really, really important, because the administrator has to make the decision. And you might claim level 4, but the administrator may assess it and say, well, on this detail, I only assess it as a level 3. And that's the decision the administrator makes. And there is an appeal process, and I'll talk to you about that, a little bit further on as we go through this. So that's why, all of that is important. You want to make it easier. You want to make it as easy as possible for the administrator to find in your favor, to find and compensate you at the level that you have claimed. And again, so that's why I say about putting your best foot forward in the documentation, if it's obtainable, in telling your story in really specific detail, and having it fit under the level that you want to be seeking, or that, we're putting forth, for example, when we're representing survivors. All right, so I've talked about the sworn declaration. There's 2 other pieces I think it'll be important for me to talk about, and we still have a little bit of time here, and I'm just watching for any questions and trying to answer and be responsive to that. But there's 2 other important pieces that I do want to talk to you about, and I just mentioned it now briefly, is the reconsideration or the appeal process. And the other piece I do want to spend a little bit of time on, and that is estate claims or representative claims. And so that is where, a day school survivor has passed away before this claims process or before putting in a claim. And so there are some legalities and some more complicated pieces to that. And I'll get into that in a minute. So those are two important pieces that I do want to spend some time on, because we're really seeing a lot of questions, particularly around this estate and representative claims part of the application process. And so let me talk about that, because I have touched on the appeal, and if we have time, I'll go back to it. But I really do want to explain as much as I can about this estate and representative claim process. And in terms of Gallings, giving advice, they give general advice on this, but in this process, depending on the circumstances, there may be the requirement to get a court to appoint someone as the estate administrator. And so that's something, again, when we're working with our clients one-on-one, as your legal counsel, we can do that. Gallings can give some advice, as I understand it, on the estate and representative claims, but they don't seek that appointment where it is necessary in those circumstances. So just to give you an overview on estate and representative claims, and again, I'm going to give you an important date on this, and this was a date agreed on in the settlement agreement. So that was agreed on between Canada and Gallings, that this was going to be the cutoff date. And that date is July 31st, 2007. So any day school class member who was deceased or died on or after July 31st, 2007, their estate or family member can make a claim for them in this process. And so there are kind of three important elements of that are important to understand, because one of the key things the administrator or Deloitte will need to approve this claim is there has to be proof that you, let's say you're representing your husband, your deceased husband, who died on or after July 31st, 2007. You have to show proof that you're named as a representative for your husband. And so an example with this would be if you were named in a will as his executor. And so you would have to provide a death certificate and proof of being named as that executor in the will. Another example is, where that may not have happened, where has to be a court order obtained that appoints you as that estate administrator, for your husband. So those are sort of some examples of what some of the legalities are that are required in these estate claims. When there is an executor or a will and you're appointed. Let me talk about when there's a deceased family member that did not leave a will, or there's no administrator, appointed. And so there's two pieces to that are important. So, and that really depends on whether the deceased family member lived on reserve or off reserve. So there's that distinction made in this process. And again, this is where I say there are some legalities in these estate proceedings. And that's where, again, when we're assisting our clients, we really, give them good advice and take some steps that need to be taken for them to put forth these estate claims on behalf of a deceased family member. So where that deceased family member does not have an executor or didn't have a will and lived on reserve, what's required in this process is that an executor be appointed by Indigenous Services Canada. So there has to be a process through Indigenous Services Canada whereby they appoint you, say if you're acting for your deceased husband, appoint you as an executor for this process. So that's, again, something that we assist with and reaching out to Indigenous Services Canada to get that appointment. Where it can get even a little bit more complicated, and this is where we are required then to seek a court order, is where a deceased family member, died without a will, doesn't have an appointed executor, and lived off reserve. And in that case, there isn't the ability to go to Indigenous Services Canada. What is required is that you get appointed as an executor by the court. And so again, that is a legal process, and that's part of the assistance that we are providing day school survivors that are representing deceased family members in this process. So those are some of the some of the complicating pieces, and probably the more harder pieces for representation on your own to be more challenging. And let me tell you a little bit about how that actually works, because I guess one of the other questions that we're being asked often is, okay, so I am the executor of my husband in his will. I'm appointed as executor, but I don't have any idea how I fill in this claims application and how I put in the details and what may be needed. And so that's where, again, we really spend time working with our clients. And it is more or less, once you get through that appointment process and that legality of what is required, it really is looking at the claims application and trying to put forth for example, your deceased husband's story. And so, for example, if your deceased husband told you throughout sometime in your marriage or throughout an incident where, he broke down and told about abuse that happened, or it was something that you talked about over the years and he gave the details, well, then you can provide those details in the application. And you can say, my late husband explained that this happened to him, and here was the impact, or here was the harm it caused him. For example, we're working with a survivor now, and her husband had told her in a lot of detail about the damage that the nuns had done to his ears and to his hearing. And we were actually able to dig back and find the medical records of when and it was way back, of when he actually attended with those two ruptured eardrums, and find those records. And again, it's not always necessary to do that, but if the information is there, we're going to put forth your best case. And so, also sexual abuse cases, oftentimes, and we know that many survivors take those experiences to the grave and never tell anyone. And sometimes if that's the case, if either in reaching out to family or other close friends, or even a doctor or anyone else that, your deceased husband might have told, and if you aren't able to find any information, or you really don't know what happened to him, maybe that is a level 1 claim, because you can't sort of provide the detail or the specifics of abuse, that might fall under level 2 to 5. But as I say, we really work closely with our clients to really help them to delve into where that information may be obtainable. So, whether it's another family member, a sister or brother that maybe, your husband confided in over the years, or maybe they witnessed it. So we're also hearing, that a brother that was, in the day school with his brother, literally saw his brother be abused by the priest or be hit and knocked out. Well, that's information that you put forward, and we could get a statement, from that brother, and you put that forward as a claim under that higher level claim, because you're providing the information and the evidence on that, and that is sufficient in this process. So, with estate claims, it can be, a little bit more work, but really, equally important as, as the claims of living day school survivors. And again, it's really that, and I'm sure, what I'm hearing from family members of deceased survivors is, my father would want me to do this, or my husband would want me to do this, this will be going to his children, whatever the case may be. And so, unfortunately, although, that day school survivor is no longer living and doesn't, have the opportunity to receive this confirmation, this compensation, and also maybe tell the story, at least his or her survivors and family members are benefiting some from this process. So, these estate and representative claims are very, very important. I'm not sure if anyone has any more questions on that issue of estate claims and representative proceedings. And as we go forward, if anyone has any specific situations, as I say, our 1-800 or our toll-free number will go up, and we're happy. Michael and I are happy to take calls and answer any questions, and just generally talk to you at any time. I see a question now. Sequin, I'm not sure if you want to ask a question here.
I'll ask the questions and then I will let you answer. So this question says, why are they telling clients they've missed a page or a signature when we've done it, delaying us more? And this process is for worse than residential school process. Why delay us?
Well, and you know, we are hearing this a lot, and I can tell you that we are very frustrated with these issues of delay as well. You know, as I said, just to reiterate, we are not the administrator. That's Deloitte's, and you know, Gallings is class counsel. So we are, you know, we are assisting day school survivors in putting these claims forward to the administrator and Deloitte's, and we are experiencing and hearing this very same frustration. You know, delay has been a big issue of concern for everyone. You know, what we understand and what we are experiencing as we are putting claims forward to the administrator on behalf of our clients is that there is a long delay to wait for compensation. The last thing we heard from the administrator was that from when a claim is put forward, level 1 claims are taking up to 6 months to be assessed, and the higher claims are taking up to 12 months. And, you know, we, as well as many others, you know, don't understand why that's the case. We also have seen in the media, and we also work with our colleagues across the country, and you know, are very frustrated and really saddened by this, because, you know, that shouldn't be the case. We are also hearing, as people reach out to us, are saying, you know, we call the claims administrator and we haven't heard from them for months after we submitted the claim. And they're saying, well, it's sitting here because you forgot to send us this or that. And again, that's unfortunate, because that causes delay. And it really should be that the administrator, when they are initially assessing the claim, should reach back out to you and say, we've received your claim, these pieces are missing. And so that's, I know, causing a lot of frustration. We've also heard from some people as well that they put their applications in the mail and they haven't heard anything. They check with the administrator, and the administrator is saying that we haven't received it. And so we've heard some of that as well, and that is of concern for sure. And so, as I say, when we are helping our clients, we put it all through electronically, and we get confirmation immediately that it's been received. And we do follow up. We call the administrator and say, we are representing so-and-so. We submitted his claim on this date. What is the status of it? We want to keep apprised of what the status of the claim is, and is it proceeding through?
Okay, so we have a question here. It says, my sister lives in the USA. How can she get help with the process?
And that's a really great question. And in fact, I can tell you that we do have clients in the US. And so two things, and I can tell you, when I did the work with residential schools, I actually traveled to the US a fair bit down in Boston. You know, we had a lot of Mi'kmaq people that moved down to Boston and worked in Boston. And so, you know, I did work with survivors in the US. What I could say is, I'm not sure, Michael, if our toll-free number works outside of Canada, but they can certainly go onto our website and contact us that way, and then we can reach out and call you back. You can email us at our email addresses there. You know, Gallings, there is information as well if you wanted to reach out to them. But certainly, you know, we can work with a survivor whether they're in Canada or the US. So it's just a matter of them initially reaching out to us, and that we will work back and forth exactly how I've described as we are working with our survivors across Canada, our clients and day school survivors across the country.
Okay. I'm just going to scroll to the side here to see if there are any more questions. Again, if you're watching today, if you're one of the viewers, please feel free to post questions now.
And, you know, as I've indicated, we're happy to field any questions after. It's a little late here in our region, but, you know, Michael and I will be back in the office tomorrow. And we do have our Facebook page. I know we see people liking that and following that, and we put information up on that regularly, as well as our website. And on our website, we have included a number of resources, such as the application the harms grid, some of these slides that we've put up here today. So there is quite a lot of information on our website. But again, Michael and I answer the phone ourselves. We're happy to talk to anybody that just wants to run something by us or even talk to us about their specific situation.
All right, so I have on the screen the Facebook page. Is that the title of it? Indian Day School Claims Facebook page? And then there's the website. And I'm going to post something else here now.
Sure.
The Indian Day School Claims website.
And that is our website, yes.
Okay, so it's www.indiandayschoolclaims.ca.
IndianDaySchoolClaims.ca, correct. And sometimes, and the reason I had to repeat it because I get mixed up with the S sometimes, and I say, Michael, what is it again? Does it have an S or not have an S? So anyway, yeah.
Okay, double check this to see if I got it right.
Yeah. And Michael's much more of a techie than I am, so it looks right there, eh, Michael?
Yeah, I'll get it for you.
You see it scrolling there at the bottom. It looks right to me.
Yeah, I'm just going to cut and paste it for you.
Okay.
And put it in the comments.
It's right here.
Then
It's with an S.
Okay.
Yeah. Yeah, it's right.
Okay. So then I'm going to post your 1-800 number. Now, I hope I got this right.
It's a 1-855 number. I'm old school. I still refer to 1-800 back in the day. It is toll free, yeah, within Canada.
So 1-855-756-4372. So in the case, if someone is in the United States, would they have a different, what do you recommend, or which way do you recommend that they contact you?
Yeah, I think our website, but I can also give you our office number, which would be, which wouldn't be toll free, but they could call directly to that office number, and then we could call them right back, so they wouldn't incur, much of a long distance charge. So, Michael, if you want to put that number up as well, our area code is 902-892-7867. And now I think calling from the US, I'm trying to remember if there's another code before that 902. But anyway, that would be the direct line to our number that wouldn't, to our office that wouldn't be toll free, is that 902, I guess 1-902-892-7867.
Got it. Okay, 1-902-892-7867. So that's the direct line, and in brackets I put it, this one is not toll free.
Great, yes, yeah. But as I say, our website, I think is pretty user friendly, because obviously I need to be able to use it, and so I'm not a techie, so we've tried to make it very user friendly. Lots of additional resources on there, like the Schedule K that I previously talked about. The entire application is in there. And some of the details of some of what we've provided today, and then our Facebook page. And and what we're doing, when people are reaching out to our Facebook page, we're just liking it back and saying thanks for following us, kind of thing, and that can start a conversation too if anybody wants to ask us any questions at any time. So again,
okay, so that was wonderful, very informative.
Well, thank you for giving us the opportunity. As I say, we're happy to answer any questions we have that anyone has. Sequin and Nathan, although I know Nathan's not there this evening, but really, a big thank you to both of you for giving us this opportunity to do that, to provide general information, for information purposes, and we're happy to get the word out and help as many people as we can. And just, even in some of what we've said tonight, whether they need us or come to us or not, I think hopefully some of the information we provided is helpful. So again, thank you very much.
I just wanted to note that in some of the comments, there were some people who were expressing some frustration, and I hope that this podcast was able to help them understand a little bit more about the process. So thank you, Pam, and thank you, Michael.
Thank you. Good night.
Good night.